Good morning, this is your Kelso Report for Thursday, February 2nd, and I'm your host, Clark Kelso. Now, when a company fails and goes through a bankruptcy, or when a bank fails and goes through a receivership, the reorganization inevitably results in some creditors being left without satisfaction, or shareholders more often than not. That is what happened in GEC CMC 2005 C1 versus J.P. Morgan Chase Bank, which involved a lawsuit brought by a former landlord of property leased by Washington Mutual Bank, which failed in September 2008, was taken into receivership by the FDIC, and which was then purchased by J.P. Morgan Chase Bank, pursuant to the terms of a purchase and assumption agreement between Chase and the FDIC, under the general authority of the Financial Institutions Reform, Recovery, and Enforcement Act of 1989, otherwise known as FIREA. You may recall FIREA. It was used the last time we had a savings and loan and banking crisis, and came in handy in the most recent one. Under the P&A agreement, Chase agreed to take certain assets and liabilities, but pursuant to powers granted to FDIC under FIREA, FDIC had extensive discretion to repudiate any contract or lease that it deemed burdensome and an impediment to the orderly administration of the failed bank's business. The two leases at issue in this case were rejected, and Chase stopped paying rent, which led to multiple lawsuits by the landlord. In the lawsuit before the Ninth Circuit, the landlord attempted to sue Chase directly based upon the terms of the P&A agreement, the clause saying we're buying assets and liabilities. Well, applying federal contract law, the Ninth Circuit held that the P&A agreement did not create any third-party beneficiary rights in the plaintiff landlord, and the landlord therefore had no standing to claim a breach of contract, since the landlord was neither a party nor a third-party beneficiary of the P&A agreement. It's very helpful to the court's opinion that the P&A agreement had a clause expressly providing that it did not create any third-party beneficiary rights. The landlord was clearly outmaneuvered here by FDIC. Next, we have an immigration law case in the Ninth Circuit. The defendant in this case was convicted of 18 counts of aiding and abetting, bringing illegal aliens to the United States for financial gain, and 18 counts of harboring illegal aliens. 8 of the 18 testified at trial and conceded they were in the country illegally. Although there was no other proof of the immigration status of the other 10, the jury convicted the defendant of all 18 counts. The defendant then challenged the sufficiency of the evidence on those extra 10 counts, saying there was no evidence that those all other 10 were in the country illegally. In United States v. Noriega-Perez, the Ninth Circuit held by a 2-to-1 majority that the jury was entitled to draw an inference from the testimony that if 8 of the 18 who were found in the load house were illegal aliens, then the remaining were also illegal aliens. Now, the key to this conclusion is that a load house is apparently routinely used as a staging area for the transfer of illegal aliens into the country. And the Ninth Circuit basically held the jury could draw a rational inference from the use of the house and the number of people who were in there who identified themselves as being there illegally. So the conviction in the case was affirmed. Our last case today is an interesting products liability action in the California Court of Appeal, involving liability of a supplier to a manufacturer. Now, the law of product liability and negligence has generally developed to protect consumers, not employees who work in the manufacturing process. And consistent with that focus, the Second District held in Maxton v. Western States Metals that a supplier of raw materials to a manufacturer generally cannot be held liable for negligence or under a strict products liability theory to the manufacturer's employees who sustained personal injuries as a result of using the raw materials in the manufacturing process. As the court explained, only in certain well-defined circumstances, such as when the raw materials are contaminated, the supplier exercises substantial control over the manufacturing process, or the supplier provides inherently dangerous raw materials, like asbestos, can the supplier be held liable. None of those exceptional circumstances existed in the case before the court, which involved a supplier who sold steel and aluminum ingots, sheets, rolls, tubes, and the like, basic raw materials for heavy industry. The plaintiff had worked for years in the manufacturing plant and suffered interstitial pulmonary fibrosis and other injuries, allegedly as a result of being exposed to toxic airborne fumes and dusts composed of the various metallic toxins of which the metal products were composed. The court explained its holding by noting that the buyer-manufacturer is actually in the best position to guarantee the safety of the manufacturing process to employees, since the supplier of raw materials undoubtedly provides the raw materials to a wide variety of manufacturers, and it doesn't really make sense to require the raw material supplier to become an expert in each of the manufacturing industries to which it sells. And that's it for today's Kelso Report. Have a great day in the law.